Let's talk about non-compete agreements. In the most recent legislative session, the legislature passed AB 276, which is now a statute related to the enforcement of certain non-compete agreements. So what does it do? Some things are different than they were previously, and a lot of things are very much the same. Let's back up for a second and talk about the reason why this statute was passed. So about a year and a half ago, the Nevada Supreme Court entered a decision in the case of Golden Road Motor versus Islam. So in that case, you had a casino host up in northern Nevada. She was working for a casino, and she had access to lists of the casino's customers and players. And after working there a bit, she had signed a non-compete agreement with them that prohibited her from working for any other casino within a certain mile radius. So she left the casino she was working for, went to work for a competitor casino, and in doing so, she took with her, excuse me, and in doing so, she took with her all of the list of players that she had been working with. And she also erased from the first casino's database that list of players. Now, the casino she left was able to recover the list, but she had already taken it, gone to the new casino, started working as a casino host, and was trying to work with those customers from the original casino. Now, her non-compete agreement, again, said she could not work in a casino within a so many mile radius at all, a competitor casino, right? It didn't specify what type of work she was able to do. And so, what type of work she was prohibited from doing. And so the Nevada Supreme Court held that the non-compete was overbroad because it didn't specify the type of work she was prohibited from doing. She could go work for a competitor casino as a janitor, and the employer where she came from would have no real interest in prohibiting her from doing that. So the Supreme Court said it was overbroad and therefore unenforceable. What's most important about that decision is that the Supreme Court said Nevada courts are not in the business of fixing your poorly written agreements. And in doing that, they decided that they're not going to modify an unenforceable, overbroad non-compete agreement. They're not going to modify it to make it enforceable. And by doing that, they rendered that non-compete agreement completely void and unenforceable. So since that case, the courts in Nevada have refused to help modify agreements to make them enforceable, modify non-compete agreements to make them enforceable if they're overbroad. Okay, so now we get to the 2017 legislative session, and we get AB Assembly Bill 276. Okay, so what does Assembly Bill 276 tell us? Well, first it talks about what we need to render our non-compete agreements enforceable. So the first thing it says is a non-compete agreement must be supported by adequate consideration. Okay, that's no different. That's always been the case in Nevada, and the Nevada courts have held that employment or continued employment is adequate consideration. So you don't have to give extra money or something extra of value to an employee to qualify as consideration for a non-compete agreement. Okay, so the second thing that they have to do, that a non-compete agreement must do, is it must be reasonable in terms of time and geographic scope. Well, that's always been the case in Nevada. That's not any different. And so the reasonableness, obviously, the more narrow the time and the more narrow the geographic scope, the more reasonable a court would find the non-compete agreement to be. We've seen most courts will enforce non-compete agreements for about a year, sometimes 2 years, but that tends to be about the maximum. And in terms of geographic scope, well, you need to really determine, are you a brick and mortar business where you can define a geographic scope where you need the protection? Or are you an online business where it's much harder to define a geographic scope? So you've got time and geographic scope. Now, what AB 276 added is it must also be reasonable in terms of the scope of the restraint the employer is trying to protect against. So, for example, in the Golden Road Motor case, we had no specific type of work that the employee was prohibited from doing. That's what we need now, and this is where AB 276 addresses that portion of Golden Road Motor, saying now you have to say, well, what is the specific restraint that the employee is bound to? If it's too broad, it's not going to be an enforceable agreement. So if you just say they can't go work for a competitor, period, that's not going to work, because they could go work for a competitor as a janitor, and you really have no interest in prohibiting that. So what I like to do is not necessarily use a job title, because job titles could vary from one company to the next. Even a list of skill sets or a list of duties could vary from one employer to the next, but still be competitive and still be something you're able to protect. So what often I like to do is say the employee cannot go work for a competitor performing the same or similar duties as what the employee is performing for us, essentially. Okay, so that's the big part of the non-compete additions that AB 276 requires. What else does the new law do? Well, it also prohibits you from restricting employees from going to work for your customers in certain situations. So, a non-compete, to be enforceable, cannot prohibit a former employee from providing services to a former customer or client of the employer if the former employee did not solicit that former customer or client, the former customer or client voluntarily chose to leave, to stop working for your company, and that former customer or client affirmatively sought the services of the former employee, of your former employee. And the former employee is otherwise complying with the valid terms of the non-compete agreement. So what that boils down to is you can still prohibit an employee from going straight to your customer and saying, hey, hire me directly and I'll do the same work for you, and I'll do it for cheaper. Okay, you can prohibit that. What you cannot prohibit anymore is the customer deciding, I don't want to work with you as a company anymore. Once they've decided that, then they contact one of your employees and say, hey, come work for us, and we'll pay you to do the same type of work you're doing for X company. Well, X company can no longer prevent that from happening. Okay. Now, there are a couple other requirements that AB 276 has, and a couple other restrictions on non-competes. So another restriction is that if the termination of employment is a result of a layoff, then a non-compete can only be enforceable for as long as you are paying that former employee. So for example, if you offer a severance package and you're paying through a certain severance term, you can enforce a non-compete after a layoff till the end of that severance term, but once the payments stop, you can no longer enforce the non-compete. Okay. Now, finally, and this is the back to the Golden Road Motor case, the legislature addresses the other issue, which is courts modifying non-compete agreements so that they are enforceable. And what AB 276 now requires is that a court, if it finds that a particular portion or all of a non-compete agreement is overbroad, the court shall modify the agreement so that it is reasonable to the greatest extent in terms of time, geographic scope, and scope of the activity being restrained. Okay, but back up for a second and think about that. We're now in court and talking about a judge modifying an agreement. Well, one judge may modify it differently or think something is overbroad more so than a different judge. So we still could end up with varying results among judges and non-compete agreements and what's enforceable, but at least the statute does get us to the point where courts are allowed now to modify those agreements to make them enforceable.